Hi everyone, my name's Zoe Bush and I'm an associate at Michael Lynch Family Lawyers. At Michael Lynch Family Lawyers, we work with clients at all different stages of marriage breakdown or de facto separations. As counsellors, you no doubt have come across and are aware of many clients who've experienced or at risk of experiencing family and domestic violence. The purpose of today's webinar is to provide you with some bit of understanding and background around the law in Queensland about applications for domestic violence protection orders, and also provide a bit of information about some recent amendments to the relevant legislation. So just to begin with is some statistics or some bit of background about how prevalent domestic and family violence is in Australia. So the latest data from the Australian Institute of Health and Welfare and the Australian Bureau of Statistics show that 2.2 million Australians have experienced physical or sexual violence from a current or previous partner. About 3.6 million Australians have also experienced emotional abuse from a partner, and data shows that a staggering quarter or 1 in 4 women have experienced violence by an intimate partner they may or may not be living with. Further, in Australia, between 2014 and 2021, the rate of domestic and family violence, sexual assault offences increased, with victimisation rates consistently higher for females compared with males. Rates for homicide and related offences do fluctuate over time. However, the number of offences range between 105 and 173 intimate partner homicides a year. This equates to effectively 1 woman was killed every 9 days and 1 man every 29 days by an intimate partner in the year 2014 to 2015 and the year 2015 to 2016. Although domestic violence victims and perpetrators can be either male or female, overwhelmingly domestic violence is a gendered issue. The most recent statistics available in Queensland show that approximately 74% of agreed persons were female and 75% of respondents were male. Now, just to, before we jump into some of the legislation, I just thought I'd go through a bit about the relevant legislation that we're dealing with and some terminology. So in Queensland, applications for domestic violence protection orders are governed by a state-based legislation. So this is an act by the Queensland Parliament, not the Federal Parliament. Such applications are treated as a civil matter. It's important to note that they're not a criminal matter or a criminal charge. The relevant legislation is the Domestic and Family Violence Protection Act of 2012. There are also some relevant rules and practice directions which are issued by the court that provide some information more about the practical side of the structure of the courts, how applications progress through the court system, and some guidance for parties and legal practitioners who practice in the area. I often find it beneficial when advising clients who are applicants or aggrieved for domestic violence in domestic violence protection order proceedings to reiterate what the main objects and principles of the Act are. The paramount principle of Domestic and Family Violence Protection Act is that the safety, protection and well-being of people who fear or experience domestic violence, including children, is paramount. The Act aims to protect people from domestic and family violence and to ensure those who are affected by family violence are treated with respect and that practical consideration is given to minimising disruption to their lives. The Act also aims to hold people who commit domestic and family violence accountable for their actions, and this is achieved by the court being able to make domestic violence orders that restrict behaviour of a person committing the violence and in some instances identifying the behaviour as a criminal offence. The Act also gives powers to the Queensland Police Service to respond to domestic and family violence incidences, and this includes the power to issue police protection notices and make their own applications. As many people are now aware, breaching a domestic violence order or a police protection notice is a criminal offence and may have some serious consequences. The main definitions and words that you'll often hear in this space is firstly a protection order. So that's an order that's made by the court for the benefit of an aggrieved against a respondent. That order will put conditions on the person who is a respondent and is designed to protect the person from violence who is the aggrieved. Now, a protection order may be a final protection order or a temporary protection order. A temporary protection order is in place whilst the matter is still before the court, and a final protection order is final and is usually in place for a period of time set by the court. But if a period of time is not set, it's 5 years. A period of time can only be less than 5 years if the court is satisfied that there are reasons for doing so. And the court indeed must actually give reasons for doing so when making a protection order for less than 5 years. Another common phrase that people hear is a police protection notice. A police protection notice may be issued by a police officer following their attendance at a domestic violence incident or following a report of domestic and family violence by an aggrieved or another person. A police officer may issue a police protection notice if they reasonably believe that a respondent has committed domestic violence and that they think it is necessary or desirable to protect the aggrieved from domestic violence. Each police protection notice will contain a standard condition that the respondent must be of good behaviour towards the aggrieved and must not commit domestic violence against the aggrieved. Police protection orders may also include further conditions, including what's commonly referred to as a cooling off condition, that a respondent may not be able to attend or be at a residence for a certain period of time, for example, 24 hours, or other conditions such as the respondent may not attempt to or contact the aggrieved. Importantly, a police protection notice is taken to be an application for a domestic violence protection order by the police officer. It continues to be in force until the matter is in court and the court makes either a final protection order or a temporary protection order, or the court hearing an application adjourns the matter without making a temporary protection order, or the application for a final protection order is dismissed. Other words that are commonly referred to in this area is a named person. A named person is a person who is an addition to the aggrieved, who is someone who's protected by an order. So this can be an associate or a relative of the aggrieved. Examples include a current spouse or partner of the aggrieved, a person who works at the same place as the aggrieved, a person who may live at the same place as the aggrieved, a person who provides support or assistance for the aggrieved, such as a family, friend, neighbour, or a member of the aggrieved's family. A named child may also be on the protection order, and this is a child who's specifically named as also being protected by the protection order. A named child may be a child of the aggrieved or a child who usually resides with the aggrieved. So that means that a child who spends time to time at the residence of the aggrieved or spends time there on a regular and ongoing basis may be named on the protection order, even if they're not a biological child of the aggrieved. It's noteworthy that the child may be a child of the aggrieved and the respondent, or just be a child of the aggrieved or a child of the aggrieved's new partner, for example, who may also be named on the protection order. The applicant is also a phrase that's commonly used for aggrieveds who are applying for a protection order by themselves. They will be also the party who is the applicant. The applicant party will also be a police officer when it's the police officer who's making the application for a protection order. The Act also allows certain other people to be authorised to make an application on or behalf of the aggrieved. Now, turning now to the background to the recent amendments that are now effective from the 1st of August 2023. In 2015, the Queensland Government received the Not Now, Not Ever report. That report was the catalyst for major legislative changes that occurred in Queensland between 2015 and May 2017. Following those amendments, there has continued to be much discussion around domestic and family violence in Queensland, including around the concept of coercive controlling behaviour. Such discussion in politics and the media has followed some high-profile domestic violence incidences that have been covered in the news, including, unfortunately, incidences of intimate partner homicide. The phrase coercive control is a social science phrase. Coercive controlling behaviour constitutes a pattern of behaviour perpetrated against a person by another person to create a climate of fear, isolation, intimidation, and humiliation. Coercive control is an intrinsic part of domestic and family violence. Such pattern of behaviour or ongoing behaviour is designed to exert power and control over another person in a domestic or intimate relationship. Such behaviour can include isolation, emotional and psychological abuse, threats and intimidation, monitoring of electronic devices and online activity, tracking movements and location, and controlling aspects of someone's life, including what they wear, when and what they eat, and if they can leave the house or communicate with others. This behaviour may also involve controlling access to money and other resources. Victim survivors of coercive controlling behaviour are often isolated from their support systems. They describe coercive control as creating a climate of fear, isolation, intimidation, and humiliation. The Queensland Government established the Women's Safety and Justice Task Force in March 2021. This task force was established to examine coercive control and review the need for a specific offence of domestic violence and the experience of women across the justice system. The task force was chaired by the former President of the Queensland Court of Appeal, the Honourable Margaret McMurdo AC. Victim survivors of domestic and family violence told the task force about how common coercive and controlling behaviours, including stalking and harassing behaviours, particularly through electronic devices, was of them and their children, and how linked it is to domestic and family violence. The task force recognised that systems needed to respond better to coercive control through a shift occurring from focusing on responding to single incidences of violence to focusing on a pattern of abusive behaviour that can occur over time. The first report of the task force was released in December 2021. It was called the Hear Her Voice Report 1, Addressing Coercive Control and Domestic Family Violence in Queensland. That report made 89 recommendations to the Queensland Government about reforms that were required to domestic and family violence services and the justice system as a whole, and it outlined a four-phase plan that included a comprehensive suite of legislative reforms. The task force did address the issue of recommending the criminal offence of domestic violence. They recommended that a new offence of coercive control be implemented, but not straight away. Chair of the task force, the Honourable Margaret McMurdo, said that the system-wide reform is necessary before the new offence comes into effect. The Queensland Government released their response to the report on the 10th of May 2022. That included an in-principle support for all the recommendations made by the task force and a commitment to creating a specific offence of coercive control. The first round of the legislative reforms occurred through the Domestic and Family Violence Protection, Combating Coercive Control and Other Legislative Amendment Bill 2022, which was introduced to the Queensland Parliament in October 2022. The purpose of that bill was to strengthen existing laws to address the patterned nature of coercive control and to limit the ability of perpetrators to further traumatise victims during the court process. That bill was passed by the Queensland Parliament on the 22nd of February 2023, and it came into effect on the 1st of August 2023. The Domestic and Family Violence Protection, Combating Coercive Control and Other Legislations Amendment Act affects and changes a number of legislative instruments in Queensland. For the purposes of today's presentation, that includes a number of amendments to the Domestic and Family Violence Protection Act. These amendments were intended to be a background to further amendments that may occur in relation to the introduction of a specific offence of coercive and control. On 22nd February 2023, the Domestic and Family Violence Protection, Combating Coercive Control and Other Legislation Amendment Bill 2022 was passed in the Queensland Parliament. The amendments arising from that Act came into effect on 1 August 2023. The Act has amended many legislative instruments, but for the purpose of today's webinar, we will focus on some of the changes made to the Domestic Violence Protection Act, beginning with the amendment to the definition of domestic violence in the Act. Domestic violence is defined in the Act in Section 8. It's a very broad definition and is extended on further in Sections 9 to 12 of the Act. Domestic and family violence is behaviour or a pattern of behaviour by a person towards another person with whom the first person is in a relevant relationship. That is physically, sexually, economically, emotionally, or psychologically abusive, coercive, threatening, or controlling. It also may be behaviour that in any other way controls or dominates the second person or causes the second person to fear for the second person's safety or well-being or that of someone else. Although the Domestic and Family Violence Protection Act does define domestic violence to include coercive and controlling behaviours, it does not define what these behaviours are. The task force found that the current definition of domestic violence in Section 8 prior to the amendments sent a confusing message about the nature of coercive control and domestic violence and may contribute to the misidentification of domestic and family violence by not properly reflecting coercive control as being a key component of domestic violence beyond what was stated in the preamble of the Act previously. The amendments therefore amended the definition of domestic violence in Section 8, emotional or psychological abuse in Section 11, and economic abuse in Section 12, to include in the Act a reference to a pattern of behaviour in addition to behaviour, so that it reads that it is behaviour or a pattern of behaviour by one person towards another. Further, amendments to Section 8 and by Clause 31(2) of the Act make it clear that domestic violence includes behaviour that may occur over a period of time, which includes individual acts that when considered cumulatively are abusive, threatening, coercive or cause fear and must be considered in the context of the relationship as a whole. These amendments were said to strengthen the system's response to coercive control through a shift from focusing on responding to a single incident of violence to focusing on the pattern of abusive behaviour that occurs over time. The Domestic and Family Violence Act further provides a list of non-exhaustive behaviours which may constitute domestic violence, and these are listed on the next slide. This includes damaging or threatening a person's property, coercing a person to engage in sexual activity, causing or threatening to cause injury or death to an animal, unauthorised surveillance of a person, exposing a child to domestic violence, following a person, repeatedly texting or emailing a person, preventing a person from keeping in touch with family and friends, removing or selling a person's property without consent, coercing a person to sign for finance, preventing a person from obtaining employment, and coercing a person to obtain social security benefits. There are quite a lot of several other behaviours that are listed in the Act, and I encourage anyone who works in the space or with people who experience domestic and family violence to read through the quite number of behaviours that are listed in the Act. It's important to again note that this list of behaviour is it's not an exhaustive list, so there certainly can be behaviour considered to be domestic and family violence that is not expressly listed in the Act. And again, under the new definition of domestic violence, the behaviour may be a single incident or behaviour which has occurred as a pattern over time. It's also important to reiterate at this juncture that domestic and family violence behaviour, as you can see from the quite extensive list in the legislation, is not just physical forms of violence. There are many different types of non-physical forms of domestic violence which constitute domestic and family violence under the Act. I consider a good way to illustrate this point in our modern day and age is to look at technology-facilitated abuse and surveillance. Such technology-facilitated abuse and surveillance is quite clearly often a non-physical form of domestic violence. In today's day and age of smartphones, internet, security cameras and other technology-facilitated abuse and surveillance is unfortunately becoming more and more common as part of domestic violence and coercive control. It is important to note that such behaviours may constitute domestic violence as defined under the Act, even if they remotely occur from the victim's survivor or through technology. Unauthorised surveillance of a person means the unreasonable monitoring or tracking of the person's movements, activities, or interpersonal associations without the person's consent, including, for example, by using technology. The Act then provides some further examples of surveillance by using technology. This includes reading a person's SMS, monitoring a person's email account or internet browser history, monitoring a person's account with social networking internet sites, using a GPS device to track a person's movements, and checking the recorded history in a person's GPS device. That can include, for example, Google Maps. The new amendments have also, importantly in this area, expanded the definition of stalking under the Criminal Code. Now, under the definition of domestic and family violence in the Act, what is now referred to as unlawful stalking, intimidation, harassment or abuse, as defined in the Criminal Code, can be behaviour which constitutes domestic and family violence. That kind of behaviour can include contacting a person in any way, including, for example, by telephone, mail, fax, email, or through the use of any technology. It can also include leaving offensive material where it will be found, given to, or brought to the attention of a person. And this, for example, can be posting offensive material to an aggrieved person's social media site, such as to their Facebook wall. It's also important to note that threats and other emotional and psychological abusive behaviour may occur electronically over text message, email, or on social media. Further examples of technology-facilitated stalking and abusive behaviour is giving offensive material to a person directly or indirectly. For example, emailing offensive pictures to an aggrieved person, or alternatively, an intimidating, harassing or threatening act against a person, whether or not involving violence or a threat of violence, and an act or a threat of violence against the person or against property of anyone, including against the respondent themselves. There have been some other amendments made to the Domestic and Family Violence Act. I will only go through a couple of them today. In addition to the definition as briefly gone through, there has been some amendments made to the law surrounding cross applications. A cross application is where both parties file an application for a protection order against each other. The task force heard that the Domestic and Family Violence Protection Act is not operating as intended in regards to cross applications, and cross applications were being used by perpetrators as a means of continuing to control and intimidate victims, resulting in domestic and family violence orders being made against the victim survivors of domestic and family violence. The amendments amended the principle for administering the Domestic and Family Violence Protection Act to include a revision of Section 4. The new Section 4E of the Domestic and Family Violence Protection Act now requires a court to identify where both parties allege domestic violence, the person who is most in need of protection in the relationship. There is also a presumption that there should only be one domestic violence order in place between the parties unless there are exceptional circumstances. The new amendments also require cross applications to be heard in the same court at the same time. The courts are also provided with some guidance with how to determine who is the person most in need of protection and how to decide cross applications in the new Section 22A and Section 41G. The new amendments also outline that the police must file or give the respondent's criminal and domestic violence history to the court. Now, this includes when matters are not police applications and are private applications. The court must also consider the respondent's criminal and domestic violence history when deciding if a protection order is necessary or desirable to protect the aggrieved from domestic violence. And the court may also consider the respondent's criminal and domestic violence history when deciding whether to vary, i.e. change a domestic violence order, or to make a temporary protection order if, in the court's opinion, it is relevant to do so. Another significant amendment is in relation to the issue of costs. The task force recommended that the Domestic Violence Protection Act be amended to specify that where a party has intentionally used domestic violence protection order proceedings as a means of committing or continuing domestic and family violence, including coercive control, that the court has the power to award costs against that party. The purpose of such a change was said to signpost to lawyers and system abusers that the court has the power to award costs against people who use the legal system to continue abusive, controlling and coercive behaviour. And in this regard, Section 157 of the Act was amended. The Act was amended to include a new ground on which the court can make a costs order. The court may award a costs order against an applicant for a protection order if the court decides to hear and dismiss the application, and in doing so also decides that the party in making that application has intentionally engaged in behaviour or continued a pattern of behaviour towards the respondent that is domestic violence. The amendments have also inserted a note into Section 157 to explain that this type of behaviour is known as systems abuse or legal abuse. And this behaviour is behaviour in which a person intentionally misuses the legal system to intentionally exert control or dominance over the other person, or to torment, intimidate or harass the other person. So that brings us to what are the conditions that you can have on protection orders. Whether or not a protection order is a final or a temporary protection order, they will all have what's called a standard condition. This condition will read that the respondent must be of good behaviour towards the aggrieved and not commit domestic violence against the aggrieved. If a child or another person is named as also being protected by the order, the standard condition will also be on the order for any named person or child, so that the respondent must be of good behaviour towards that person and child and not commit associated domestic violence against the named person and child. This means, in effect, that if the respondent perpetrates any further domestic violence, that this may be investigated by the police and they may be charged with a criminal offence or contravention of the protection order. This is commonly referred to as a breach. I'll address this a little later in this presentation. Protection orders may also have additional conditions. So the applicant for the protection order, so that is the aggrieved applying for the protection order or the police applying on behalf of the aggrieved, may ask the court to add extra conditions on the order to prohibit the respondent from particular behaviours. The court may also consider imposing extra conditions to help the aggrieved, their relatives, associates and children to be protected from further domestic and family violence. Such additional conditions can be quite extensive and wide-ranging, and they can also include things like preventing the respondent from approaching or attempting to approach the aggrieved or a named person, including stating a minimum distance for the respondent to stay away from the aggrieved or a named person, contacting, for example, by telephone, text message, email or social media, or attempting to contact or asking someone else to contact the aggrieved or a named person, locating or attempting to locate the aggrieved or a named person, engaging in other behaviour towards a child or of the aggrieved, such as going to that child's school or daycare. The court may also order the respondent to return certain property of the aggrieved, allow the aggrieved to retrieve property from a former home, and also may order or prevent or limit contact between the respondent and a named child, recalling that this may also include a child that is a child of the respondents, to the extent that it's necessary for the child's safety and well-being. Noteworthy in Queensland is also that the court may impose conditions for the protection of an unborn child where the aggrieved is pregnant at the time of the domestic violence protection order being made. In Queensland, we also may have an order made for the police to accompany the respondent to the residence of the aggrieved to recover his undisputed personal property. Of particular relevance to technology facilitated abuse is conditions in relation to social media use. A condition may be made that the respondent is prohibited from posting or publishing comments about the aggrieved on social media. Another example relevant to unauthorised surveillance and tracking is that a condition may be made that provides that the respondent is prohibited from locating, attempting to locate, or asking someone else to locate the aggrieved and named children and named persons. For example, a respondent may be contravening this condition if they're asking around if anyone knows where the aggrieved lives or works, or they're trying to locate the aggrieved using the Find My Phone application or any other such applications. A condition may also be made that the respondent must not electronically monitor or track or attempt to electronically monitor or track the movements or communications of the aggrieved and named person and named children by any means. For example, using electronic applications, AirTags, or going through the GPS's history of the aggrieved. A particularly noteworthy condition that the court may make is what's commonly referred to as an ouster condition. This is a condition that prohibits the respondent from remaining at or entering or attempting to enter particular premises or approaching within a certain distance of the premises. This can be the home of the aggrieved or where the aggrieved lives, works, or frequently attends. The Act, in fact, requires that when a court makes a domestic violence protection order to consider whether or not to impose an ouster condition on the aggrieved's usual place of residence. This is even if the condition is not sought by the applicant for a protection order. Before deciding whether to include such a condition in an order, the court must consider a range of factors, including, for example, whether the aggrieved and any child living with them can continue to safely live in the residence if the ouster condition is not made, any views or wishes expressed by the aggrieved about imposing the condition, the need to ensure continuality and stability in the care of any child living with the aggrieved, and the particular accommodation needs of the aggrieved and any affected child or the respondent. It's important to note that an ouster condition can be made regardless of whether the respondent has a legal or equitable interest in the premises. That is whether or not he owns or rents the premises, or where the aggrieved and respondent live or live together in the premises. The respondent if a ouster order is made, may be allowed to return within a certain period of time to the premises to recover undisputed personal property. And such a condition is often referred to as a return condition. A police officer may be required to supervise the ouster or return conditions. If the respondent does not comply with those conditions, they may be considered to be in breach of the domestic violence protection order, which may be reported as a criminal offence. Now that brings us to exceptions to conditions. Domestic violence protection order conditions may have exceptions written underneath them on the order. I've outlined on the slide some exceptions which are commonly written under conditions on protection orders. For example, if the condition for a respondent not to approach an aggrieved has the exception for when appearing before a court or tribunal, or except for the parties to attend an agreed conference, counselling or mediation session, that the respondent will not be in breach or in contravention of the order if he's approaching or near the aggrieved only for the purpose of such accepted events. Another exception which may occur is with the prior written consent of the aggrieved. For example, if the aggrieved provides written consent, if that exception's on a no contact order, and the aggrieved provides her written consent for the respondent to contact the aggrieved by a certain means, for example, via email only, the respondent will not necessarily be in contravention of the protection order, provided that he strictly complies with that. Written consent may of course be revoked at any time and may be revoked verbally. So how does an applicant file an application for a protection order? Application for protection order forms are commonly referred to as a DV1 form, and they're available online at the Queensland Court's website. Applicants can also obtain a hard copy from the Magistrates Court Registry. They can print out a hard copy as well to complete from the website, or they can actually now complete an electronic online form and they can then be printed. It's important to note that there's no filing fee or other fee payable for an applicant to make an application for a protection order. They can be filed at any local magistrates court, but it's important to note that since 2015 there are some specialist magistrates courts in Queensland. This includes courts which currently operate in Southport, Beenleigh, Townsville, Mount Isa, Palm Island, Cairns and Brisbane. These specialist magistrates court were recognised by the Women's Safety and Justice Task Force Hear Her Voice Report 1, which was released in 2015, and therefore that court model has expanded since. The importance and significance of the specialist court model has also been recognised in the current reforms. Specialist domestic and family violence courts offer a dedicated specialist magistrate with specific training, knowledge and experience in domestic and family violence matters, as well as a number of other support services, including duty lawyers to provide advice and representation to both parties, court support workers for the aggrieved, and support and liaison workers for the respondents. They may also provide specialist information and access about domestic and family violence perpetrator programs. Once an aggrieved has submitted an application to the court, the police are responsible for serving or providing the application to the respondent. It's important to note for applicant aggrieveds in particular that the respondent will be given a full copy of their application and all attachments which they give to the court. If an aggrieved does not want the respondent to know her address and contact details, she can leave her contact details on the DV1 application form blank to ensure that these aren't given to the respondent. And she can then file a domestic violence aggrieved confidential address form with the court to make sure that the court has her details. When a applicant files a application, she can ask the court to make a temporary protection order prior to the respondent being served. It's important that this is stated clearly and filled out correctly in the application. The court will then consider whether or not to make a temporary protection order prior to the respondent being told or served with the application. It's important for the court to have information to consider such requests, that the applicant outlines as much information on the application that they can, and provide any evidence of any immediate need for the protection order. Of course, if it's at all possible, it's advisable for private applicants to receive legal advice prior to filing their application. But of course, this is not always possible. Once the application is filed and a temporary protection order is made or not made, the application is then served by the Queensland Police Service. The application document itself will have a court date noted on it. And it's important that an aggrieved, if she's a private applicant, attend the first court date. The respondent will also be required, once they're served, to attend the first court date. There are a number of options that a respondent has when responding to an application. This includes responding, consenting to an order on a without admissions basis. So that's essentially saying that they'll agree to an order being in place, but not admitting to any guilt. There are a number of other options that an application may be resolved by, and this includes the agreeing to withdraw the application. For example, if they receive legal advice around that, and of course, prior to anyone doing such, they should obtain legal advice. The aggrieved may also accept the signing of an undertaking or a promise that the respondent will not commit domestic violence, plus any other conditions that the aggrieved seeks. And on that basis, that the aggrieved applicant withdraws the application. The other way that a matter may be resolved is if the matter proceeds to a final hearing, and that is that the respondent does not agree or he contests to the making of an order. And in that case, the matter will go to a final hearing before a magistrate, and they will determine whether or not a final protection order is to be made on the evidence. If the respondent is contesting the application or asking for it to be given a final hearing, the court will then provide directions for the parties on how the matter is to proceed towards a final hearing. The court will usually provide the parties with an actual written document that provides the directions on how the matter is to proceed. And it's really important that parties, particularly private applicants, note any dates that they are meant to be submitting evidence to the court by. It's often at this stage that it's important that parties obtain some further legal advice in relation to preparation for a final contested hearing, or responding to an application and the preparation for the final contested hearing. At the final contested hearing, both parties will need to give evidence in the witness box, and they can be cross-examined by the other party's solicitors. There are some restrictions in place on aggrieved parties being questioned directly by the respondent to the protection order proceedings. So it's very important, again, that parties seek some advice about that specific issue and preparing for the hearing generally. Now, at a final hearing, the magistrate will need to make a decision whether or not to grant a final protection order. A final protection order will be made after a final contested hearing if, firstly, there's a finding that the parties are in a relevant relationship, i.e. that they're in a spousal relationship, a family relationship, or a couple relationship. There are a number of sections in the legislation from section 13 that outline different types of relationships which the court may find to grant a domestic violence protection order. It's important to note that parties do not have to be living together or in a de facto relationship for their relationship to be a couple relationship. The Domestic and Family Violence Act also doesn't apply to certain relationships, that is, that they're not a relevant relationship. For example, neighbours, housemates or friends. And also in relation to applicant aggrieved, a person under the age of 18, even if they're in a family relationship, for example, a parent-child relationship or a sister-brother relationship, they can't apply for a protection order against that person if they're under 18 as an aggrieved, with that family member being the respondent. but they may apply, or the police may apply, for a protection order when the aggrieved and or the respondent are in an intimate personal relationship or a couple relationship, and either or both of them are under 18. Now, the second requirement is that the respondent has committed domestic violence against the aggrieved, and that's the definition in Section 8 and the other subsequent sections of the Act that we went through previously. The final requirement of the court to find at a contested hearing is that the domestic violence protection order is necessary or desirable to protect the aggrieved from domestic violence. The implication here is that the legislation contemplates cases that it is possible for the court to make a finding that domestic violence has occurred, yet that it is not necessary or desirable for a final order to be made. The Act provides guidelines for the court in making this decision of whether or not a protection order is necessary and desirable. And that includes the court must take into consideration the principle of the Act that the safety, protection and well-being of people who fear or experience domestic violence are paramount. And that again is outlined in the principles in Section 4 of the Act. The court also may consider whether or not a voluntary intervention order, commonly referred to as a domestic violence program, or also has a number of common names, but under the Act, a intervention order, voluntary intervention order program, whether or not that has been made against the respondent and the respondent has complied with and completed that voluntary intervention program. There is a large number of case law regarding the issue of whether or not a order is necessary and desirable, and of course each matter will turn on its own circumstances. The court's assessment will depend on the particular facts of the case and circumstances, and this can include whether there's evidence of past domestic violence and conduct, genuine remorse on behalf of the respondent, if the respondent has engaged in any rehabilitation, counselling, support services, whether they're in any medical treatment, for example, for any underlying mental health issues, and the compliance of the respondent with any temporary protection orders. There also can be consideration given to the circumstances or change of circumstances of the parties, including whether or not the parties are separated or one party's relocated. It will also be relevant circumstance for the court to consider any children and whether or not the parties will have communication going forward. As a practical tip, protection orders, as we've gone through, are a state-based legislation. However, orders made in Australia or New Zealand on or after the 25th of November 2017 will be automatically recognised in both countries and all states and territories. It's called the National Domestic Violence Order Scheme, and essentially it applies automatically. This means that an aggrieved who moves interstate will no longer have to manually register their order in the state that they live in. And also, for example, if a client lives in Queensland and moves to New South Wales, or they live around the border, they'll no longer have to register that order in the new state or in New South Wales. A question that we often get asked in family law matters is in regards to the interplay between protection orders and family law parenting orders. It's important to note that domestic violence protection orders are not necessarily deciding who a child lives with or who they spend time with, although of course they can be named on the protection order. Whether or not a child is named on a protection order is separate to their ongoing living arrangements, but of course respondents have to comply with the conditions of a protection order. That is to say that if children are named on a domestic violence protection order, it does not replace a parenting order or necessarily determine that that child shouldn't spend any time with the respondent. There can be quite a complicated interplay between domestic and family violence orders, complying with them, and also parenting arrangements. So it is important that people obtain some advice and assistance. Generally speaking, there can be an exception sought to conditions that allow family law court orders to be in place. And certainly, generally speaking, respondents do seek such exceptions quite frequently. They're commonly referred to as the family law exceptions. Of course, the court can also grant exceptions to enable the parties to attend mediation or conference, for example, to decide future parenting arrangements for the children. It's also important when parties are applying for protection orders that they provide the court with a copy of the domestic violence protection order to enable the court to be aware of this. And in fact, it's a requirement under the Act that they do so. If applicant aggrieved have any concerns in relation to parenting arrangements for their children and the safety of their children, I would always encourage them to seek some further assistance with obtaining formal arrangements, whether or not that's orders through the Federal Circuit and Family Court, in addition to the protection order area. Another common question is, what if the aggrieved and respondent own property together? So again, a protection order is not in lieu of or a substitute for a property or financial settlement. So such matters like child support, financial and property settlements are dealt with in the Federal Circuit and Family Court of Australia and not dealt with in domestic and family violence proceedings. A court, as we discussed previously, can impose an ouster condition to stop respondents from entering or living at a place. This is even if both parties join the property or rent the property together. The distribution of property at the end of a relationship, again, is not decided by a protection order, and I would certainly encourage the aggrieved and respondent to seek legal advice if they own any property together, even if it's subject to an ouster order, and they are separating or not wanting to continue the relationship. What to do if there is a breach of the protection order? So whilst the protection order application itself is a civil matter, a breach or contravention of the protection order may result in criminal charges for the respondent. The breaches or contraventions aren't automatically actioned, and only the police can charge the respondent with contravening or breaching the protection order. So the aggrieved or another person may report a breach or a suspected breach of the protection order. Of course, if the situation is urgent, happening now, or there's immediate threat to someone's life, then the aggrieved or another person may contact the police to report the incident and seek assistance. Of course, in an emergency, they can dial 000. If the contravention is not happening right now, for example, if there's text messages or emails, those kind of things, the client may report the domestic violence by attending at their local police station and calling Police Link. If the aggrieved tells the police that the respondent has breached the protection order, then the police have powers to and indeed must investigate, and they then may charge the respondent with a criminal offence. If the respondent is found guilty of contravening the protection order, they may have a criminal conviction recorded, and depending on the severity and the circumstances, if they're found guilty of breaching the order, the magistrate can order that the respondent do community service, be put on a good behaviour bond, be fined, or be sent to prison. There's a number of different possible outcomes there, of course, and anyone with any such issues should seek some criminal law advice. So what do you do if a client indicates to you that they may be experiencing domestic violence? Firstly, the safety and protection, safety of that person is paramount. Of course, if the situation is urgent, happening now, there's an immediate threat, they should dial 000. Clients may also report domestic violence by attending at their local police station or calling Police Link. As discussed earlier on, the police may investigate the matter and elect to issue a police protection notice or file an application for protection order on behalf of an aggrieved. I often encourage clients to collate evidence, including text messages, emails, or social media posts, photographs that they may have taken throughout the relationship, even years ago, and note down, if they do have the time prior to attending at the police, some thoughts to collect their thoughts on what have happened, and also they can provide those notes to the police as well if they're comfortable doing so. Parties, of course, may also attend at their local magistrates court and file an application for a protection order themselves. Whilst parties do not need to obtain legal advice prior to filing an application, if there is time, I would encourage parties to obtain legal advice prior to filing an application. And I have included in one of the subsequent slides the details of some community-based legal services which may be able to assist. Of course, I do reiterate that parties can make a private application without seeking legal advice first. It's not compulsory. Of course, if they feel like they need to do so. There are a range of support services that are available both at the court and that clients may be referred to reach out to. This includes their local domestic violence support service. There's information available online about a number of local domestic violence support services, and I would encourage you to familiarise yourself with your local service. I have also outlined on this slide some support and counselling services which you may refer clients to. For example, 1-800-RESPECT is a national confidential information counselling and support services. They can be contacted by phone or an online chat 24 hours a day, 7 days a week. Men's Line's also a national support service that offers free professional 24-hour counselling support for men with concerns about mental health, anger management and family violence, whether they're using family violence or experiencing family violence. DV Connect Women's Line is a Queensland-based service. It's a free helpline for women and their children in Queensland who are experiencing domestic violence. And they can provide assistance and referrals for emergency transport and accommodation, specialist crisis counselling, safety planning, information, other referrals and support, and also safe accommodation for pets through a Pets in Crisis program. They can be contacted 24 hours a day, 7 days a week. There's also free legal advice and assistance available from community-based legal centres. Women may contact the Women's Legal Service. There's also the Women's Legal Service Remote and Rural Advice Line. And Caxton Legal Centre provides support for both women and men in domestic and family violence. So thank you for listening and watching today's webinar. If you have any questions, we would certainly encourage you to reach out to our office. Know that, of course, we've breezed through everything in very brief detail and it's quite a complicated and emerging area of law. So certainly if you have any questions about anything in particular or require any assistance, feel free to get in contact with us. Thank you for your time and attending today's webinar. If you would like to seek the assistance from Michael Lynch Family Lawyers, you're more than welcome to get in touch with us. Certainly can assist you with a range of domestic family violence protection order matters, in addition to any family law property and children's matters, including any matters that have an underlying feature of domestic and family violence. Again, thank you for listening today, and I hope that you found today's webinar informative.